The People's National Congress Reform, PNCR, presents Nation Watch.
Hello and welcome to today's edition of Nation Watch, a production of the People's National Congress Reform. My name is Mervyn Williams, your host. For today's Sunday, 13th November 2022, we'll be discussing GECOM, the list, and the local government elections. Commissioner, Guyana Elections Commission, Mr. Vincent Alexander. Welcome, sir.
Thank you very much, Morgan.
It's always a privilege to have you on Nation Watch to explain to our viewers the issues that I'm sure no. So thanks again for joining me on Nation Watch. Now, the Guyana Elections Commission was established pursuant to Article 161(1) of the Constitution of the Cooperative Republic of Guyana. It is an independent commission. It is a commission which is charged with setting policies for voter registration, maintenance of voters list, and national, regional, and local government elections. There was a time when the Election Commission was in fact a body that sought to discuss issues and arrive at a consensual position with respect to the Elections Commission in the mind of many Guyanese does not appear to be as independent as it once was. What are your views on that suggestion?
I think your reference to "as it once was" is a reference to the commission under the chairmanship of Dr. Steve Suresbali.
Precisely.
And a lot of what it once was had to do with the personality at that time of the chairperson who sought consensus. I say that to say that the fault line really has to do with much more than the commission itself. In my humble opinion, the fault line has to do with the nature of politics and the political culture that affects the country. I almost said infect the country. We do not have a political culture that facilitates partisan, non-partisan engagements. And so even in the instances when you are non-partisan, the population out there looks to you as being on one side or the other, So that I would say that our bigger problem is a problem of our political culture, our apparent inability to come to the table with clean hands and to be non-partisan, even though we may have a political preference. So in that context, chairperson can become GECOM itself, because the composition in the first instance reflects the will of political elements. In the second instance, the political elements obviously expect the commissioners to be responsive. And the commissioners themselves, in many instances, if not most, are responsive. And so it leaves it largely to the chairperson to be the sole decision maker. And if you don't have a chairperson in the caliber of a Suresbali who consciously seeks consensus or sought consensus, then you're likely to have a problem. And that problem could become worse. It's also infected by the non-partisan nature of politics in Guyana.
Well, it is interesting, is it not, that what we have now at the level of the commission are, on the one hand, 3 commissioners who were nominated by the governing party, and 3 commissioners who were nominated by the now in opposition party, with the chair who is supposed to facilitate, or who is expected to facilitate, the kind of conversation that churns out consensus. But the commission as it is now has been reduced to a one-person commission, in the sense that the 2 sides disagree, and the chair steps in with what is called now a ruling. And that ruling is final. It takes no consideration of merits or demerits of arguments from either side. So what you have now is, in fact, a one-person commission. How helpful is that to the building of our democracy in this country?
I would respond to your contention that you have a one-person commission from 2 perspectives. Indeed, much is left to the chairperson to make the decision. Unfortunately, we do not who facilitates a discussion, who gives guidance, who seeks consensus. We have a chairperson who behaves judge-like. Insofar as she does not engage in the discussion in a manner to interrogate people's views, to lend an opinion to what's being discussed, but comes up what she has in the past referred to as a ruling at the end. But having said that, one also gets the impression
Sorry.
her rulings are biased. Her rulings are leaning towards a particular set of commissioners. And therefore, in that regard, whilst it appears to be it's really, to a very large extent, 4 versus 3. Because on every important issue, the chairperson has ruled, so to speak, in the favor of the 3 commissioners appointed. Would argue that much of the ruling really cannot stand intellectual and logical scrutiny. And therefore, in that regard, the extent to which the ruling comes down on the side 3 presidential commissioners, so to speak, it's, yes, a one-person commission, but at the same time, a 4
It's
versus 3 commission.
Influenced by 3.
Yeah.
The positions tabled by 3.
Yeah.
Now,
In
some interesting choice of words there. Here's the People's National Congress reform, the leader of the People's National Congress reform in his capacity as leader of the parliamentary opposition, Mr. Aubrey Norton, speaking to the nation regarding this most recent list of electors. He said that this list, but it is irrelevant, I'm paraphrasing here, to local government elections. It speaks to being a list for the election of persons to the National Assembly and to the regional democratic councils. It is void of any reference or structure supportive of local government elections. There are, 80 local authority areas, 10 being municipalities and 70 being neighborhood democratic councils. In those 80 areas, there are 590 constituencies. Any list of electors for local government elections must provide for the constituencies. This diversion, this difference that emerges with this newly published list clearly does not, this does not provide for local government election. This is the contention of the leader of the opposition. How do you explain this list that GECOM has published?
Let me first of all make a comment on your reference to a bloated list. Guyana has the tradition up to 2007 of seeking to have registration that would produce a new register of registrants, and as a consequence, a new voters list. We have that tradition. I think that's the first point we need to make, because there are people today speaking as if this question of so-called clean list is something out of the blues. We have the tradition. And we sought in 2008 to ensure that that tradition continued by agreeing that periodically we will have house-to-house registration. That was a consensus. That was unanimous. That we didn't have it in 2016 and 17 had to do with monies not being allocated. No other reason. And so we saw in 2018 that monies were allocated, with all agreeing. It was complete agreement. So that we ourselves of cleansing, so to speak, the list periodically. And so one has to ask the hard question as to why have we now sought otherwise? Of course, we have a situation where the Chief Justice ruled that we cannot extract names off of the National Register of Registrants, except for people who have died and proof has been provided. And that's the only mechanism really available. But that does not altogether answer the question that is posed. Does that ruling necessarily mean that you can't take names off of the voters list? Because they're two different instruments.
Yes.
The National Register of Registrants arguably should have the names of everyone who is a Guyanese, whether home or abroad. But should the voters list have the names of everyone who are not necessarily available to vote? And is there a way in which one could have a voters list that does not have those names, but does not preclude it if the persons avail themselves? So the question is, how do we deal with the problem of quote-unquote a clean voters list without interfering with the franchise that the Guyanese is entitled to? And the extent to which you have a process called claims and objections is the extent to which someone whose name has been taken off because he or she might have been overseas can get himself or herself back onto the list. And there's no reason why other mechanisms cannot be put in place to ensure that such persons, if in the country, are back on the list. But we seem not to want to solve that problem. We seem to want to ensure that this list continues to have names of persons who are overseas on it. And in the face of the revelations of the 2020 elections recount, that must be a matter of concern. Because notwithstanding all that people are trying to say, the fact of the matter is that the recount and the information revealed in that recount and the verification provided by the chief immigration officer shows that there were hundreds, if not thousands of persons who were voted for the country. So there is a real problem that is not being addressed, that could be addressed by mechanisms that are presently in place on one hand, but by seeking to put other mechanisms in place. And so let me tell you about mechanisms presently in place. Little is said about the National Registration Act and its regulation, which provided for the chief immigration officer to periodically provide the chief registration officer with the names of persons who have been out of the country for a prolonged period. And it further provides for the chief registration office to make a determination as to how those names are treated in relation to the register, and more specifically to the voters list. But it also goes on to say that if perchance those names are taken off, a mechanism should be in place for those persons to make a claim to have their names replaced on the list. And the claim there is not necessarily the normal claim of objection we are speaking to. It's a mechanism we have never put in place. As much as we have never activated the provisions of the regulations of the National Registration Act. And that we had those provisions clearly suggested we understood the problem that we could be faced with. Because the problem of overseas people is not merely excluding people from the list who are overseas. Thousands of Guyanese, for instance, between 2008 when we last did registration and now, who have died overseas. And there's absolutely no mechanism to take them off of the list. So anyone who tells me that every Guyanese should be on the list is saying to me that every dead person overseas should be on the list. There's no mechanism to take them off. And those are issues that we've got to address, not only theoretically, but we have to address them because we have before us the evidence that these dead persons overseas, somehow or other, have managed to cast votes in our elections. So that there is a big problem with the list itself that there are those who are refusing to address. Some of them smartly are saying, well, when we have constitutional reform, we'll look at that. And there's some of them in GECOM who are saying, well, we are not against the mechanisms, but we're not ready yet. And whilst they're saying that, they're proceeding to the election with that list. To come to the second thing which you referred to, the relevance of the list to the election.
So the local government elections. Sorry.
Our laws provide for local government elections to have two things that are not pertinent to general and national elections. Those two things are residency in the first instance. Must be resident. And the second thing is that the electoral list must be a list reflecting the constituency and the
Those
local
living inside
area.
Yeah.
And the law speaks specifically to this question of residency, which we have ruled out in relation to national elections. It says one should be resident, that it should be determined that where one is registered is the place where one is considered to be resident based on a number of criteria. The law is very detailed in this. It talks about where do you eat, where do you sleep,
Right.
and all of that.
Right.
And so in the preparation of a local government list, what is required is that when you go to claims and objections, which is what refines the list for elections, people should be able to make objections and or claims based on residency. But if you do not extract the preliminary list that you will use for claims and objections on a constituency and local government area basis, and if you do not tell the populace that you have the right to object to someone whom you know, who might be alive, but who you know is not living in the local area, then the list will not be cleansed in the manner because persons will not know that they should and can object to living persons who are living somewhere else. And even those who are alive, and those who are alive and living somewhere else, themselves may not understand the need to make a claim to have their name removed from where they live to where they're presently living. So that we have that problem that has arisen because the manner in which this list has been proceeded with did not allow for that kind of claim and objection based on constituency and local government area. There has been a lot of discussion on this matter in GECOM for an extended period with a lot of pushback. But it is what it is. And so we see now that there is something gazetted that is seeking to do some correction, having done the wrong thing in the first instance. And I would argue that the wrong thing having been done may well be a question of the competence of those who are administering our system. It will be a question of the confidence. So the chickens are coming home already. But in the attempt to correct, there is still a fault line that's significant. And that is that we have already established of nominations. And one can only correctly and properly submit nominations if one has at one's disposal the list already cleansed in relation to constituencies and local government areas. And so even as they attempt to make the correction, the timeline for nominations now conflicts with the availability of that
the information.
finalized list. And therefore, again, we are moving towards an election, a tremendous imperfection, with the electorate not having the opportunity to use a list that is pertinent to the exercise which we are undertaking. And therein lies the problem.
Mr. Alexander, Article 12 of Guyana's Constitution says as follows, quote, local government by freely elected representatives of the people is an integral part of the democratic organization of the state, end quote. You have just described a situation which suggests to me, a layman, that GECOM is in fact either quite close to violating or may have violated the provision of Article 12 of the Constitution. Because how can you freely elect your representatives when you do not have the material, and this is a list, electors in a particular area or persons eligible to be elected in a particular area? And we're talking about 590 such areas, constituencies. What's really happening at GECOM? Is there no respect for the constitution of this land?
I think we need to go back to the first point we were making about the nature of GECOM. 4 versus 3 and a one-person ruler.
So that logic, constitutionality, conformity with statutory laws fall outside of what is expected of the four?
Let me tell you why I'm going back to what we discussed earlier. We have a national electoral system that facilitates constituencies. And there are 10 constituencies.
10, precisely.
One would assume that the spirit of the law, in the instance of the national elections, would expect that persons who are candidates for constituency seats would reside in those constituencies. One would expect that. It might not be the letter of the law, but certainly the spirit of the law. The spirit of the law and the electoral practice in other jurisdictions. But let us examine what occurs. I would argue that if one makes the examination and one looks at the list of the various, see a particular party has embraced the practice of imposing upon constituencies
Persons, not ordinary
representatives
residents.
who are not resident in those constituencies. And I say that to say that it is a cultural question again. And therefore, they see nothing wrong with having the same disposition towards local government. This is not about representation. It's about winning and controlling. And so it is the same thing being done in an instance where the letter of the law requires otherwise. And that is what's critical here. That the letter of the law, the spirit is there for all of our elections. The letter is there in this regard for local government elections. And we see a defiance of the spirit being brought to a defiance of the letter. And so basically what we do in what we see in is people operating in their interests and not being servants of the rule of law and not caring much about the rule of law, though they may mouth off about the rule of law from time to time. And the extent to which people are placed in offices who are servants of those who behave manifest. And that might well be the problem that we face with the GECOM, both at the level of the commissioners and, God forbid, at the level of the administration.
Now, you have outlined the challenges. How reasonable or how lawful is it to expect that the deadlines provided by GECOM administratively for the purposes leading up to local government elections, given what you have outlined? I believe that dates have been set for the submission of symbols, the 20th or the 21st, I think it is, of November, and a date has been set for nominations to be submitted. In the absence of this specifically required list that speaks to constituencies, how reasonable, how lawful would it be to continue on the path with these given timelines?
I would certainly consider it not lawful because what it is doing, it's interfering with rights. And where you are in breach of the rights of individuals, then in fact you're in breach of the law. So I would not consider it to be a lawful act. It's a breach of the rights of individuals, and those rights are protected by the Constitution, as you correctly identified. And not only are they protected by the Constitution, but those rights are articulated procedurally in statutes, which seek to determine how we realize the rights that are protected by the Constitution. And so the question of residency, the question of having the list based on constituencies and local government areas are what you can find in the law that seeks, in the case of local government, to ensure that the rights people are entitled to are protected.
Are there safeguards? Do you have recourse as commissioners to challenge this situation? And if you do, are you prepared to? Have you initiated challenges at the level of the commission? And if you have, how successful do you envisage those to be?
Let's say that in the first instance, the process I referred to that has now been undertaken only became possible because commissioners spent literally months arguing the case. And so there's been some degree, though not a sufficient degree, of responsiveness in that regard. There are those of us who have taken the position that for the reasons that we have been referring to here and for other reasons, that we do not at all support the holding of the elections at this time. And we have made it very clear that we are not supporting the holding of elections that are required for the holding of elections have been done, starting with a review of GECOM's system that would allow them to see where there are fault lines and to correct those fault lines. That has not been done. We have talked about the possibility of biometrics that can contribute to addressing the problem of quote unquote the bloated list. That too has not been given attention. And now we have a situation where the specific list preparation is not relevant to the nature of the elections. And so for us, it's more a question of not having than having the elections. But again, we have a 4-3 situation. And therefore, such matters beyond the commission really become highly political matters that will have to be dealt with by the electorate themselves. Suffice to say that it isn't the practice for commissioners to take these matters to court. That has never been the practice. And whether or not they go to court, I would think is a matter for advisement of the politicians.
Viewers, you're tuned to Nation Watch, a production of the People's National Congress Reform. I'm your host, Mervyn Williams. My guest is Mr. Vincent Alexander, Commissioner at the Guyana Elections Commission, and we're discussing GECOM, the list, and local government elections. Mr. Alexander, I read an interesting attributes a very surprising position to a foreign envoy in Guyana. The British High Commissioner to Guyana is quoted in a news report as saying some interesting things with respect to the voters list. She is quoted as saying, "From what I have been told, yes, I am satisfied. I think the mechanisms are there." And she's speaking about the list of electors. She's satisfied with the list of electors. She goes on to say, "From what I have heard, I think the list is good enough. And I think we just need to make sure that there are those mechanisms in place to make sure it is regularly updated and verified." An interesting pronouncement coming from the British High Commissioner to Guyana with respect to the list, talking about what she has heard and what she has been told. Has there been any official interaction between the Guyana Elections Commission and Ms. Miller, the British High Commissioner to Guyana?
Not to my knowledge. There's been no such interaction. I think it's an interesting question that you asked, because I was asking myself, who told her? And you have to be careful because we are into a lot of partisan politics. And if the country is caught up in partisan politics, by whom could she be told? Is it a consensus across the political working with some partisan politicians. So she has to be careful how she enters into the arena here, and would be better off not making such comments, because who would have told her? Your question suggests, well, if GECOM told her and GECOM in one chorus told her, then she's well told. But GECOM hasn't told her, as far as I know. And in Guyana, anybody who tells her is a partisan politician.
Well, might I interject here to say to you, sir, that within recent months, it has been made very clear that all of the opposition political parties are uncomfortable with the list. Civil society is uncomfortable with the list the way it is. The labor movement is uncomfortable with the list as it is. The only entity that has been coming out in defense of the voters list in this country has been the People's Progressive Party. So by deduction, it would appear that not just a partisan political person may have provide the advice, the information that form the basis for this statement, but it has to come from the People's Progressive Party by deduction.
Let me respond to you this way. Listens carefully to the People's Progressive Party, that there is not a homogeneous, a monolithic position on this matter. Yes, there is a vice president who's out there and has been very clear about his position. And I'm told he's general secretary, so probably about the party's position. But if you list, I went to consultation for the reform of GECOM. And the response of the Attorney General was, look, all right, there may be that problem, but what's the solution? That was his response. Give me a solution. The judge has ruled. What's the solution? It therefore occurs to me that there are those who have recognized the problem, who may not have an interest in resolving the problem, but have recognized the problem. So that even, I'm being bold to say, that even if one clearly analyzes statements coming from spokespersons of the People's Progressive Party, the problem is so evident, and it is so illogical to say there isn't a problem, that they have sought to distance themselves from saying there isn't a problem, but has posed the question, how do we solve it? As their way of not solving the problem, but not saying there isn't a problem. And so, speaks to this problem in Guyana, to a very large extent, we'll be speaking from a partisan perspective. And I'm even saying that those who say there's a problem are partisan, but there is logic in what they're saying. There is logic in what they're saying. And so I would want to attempt to give the British High Commissioner, Her Excellency, a second bite at the cherry. And why would I do that? Her statement gives her wiggle space. In her statement, she said she's told that there are mechanisms.
Yes.
The extent to which she has not defined the mechanisms, and the extent to which she has not said that there are mechanisms at work, as opposed to there are mechanisms which may come into play, is the extent to which she could still wriggle out and say, for example, that biometric is a mechanism that can be used.
There has been public criticism of the British High Commissioner's statement by an opinion maker in, and I think it's an op-ed or it's an article, Mr. G.H.K. Lal has spoken to this issue, and he does not have a view that is appreciative of this kind of intervention. In that regard, which says sovereignty belongs to the people who exercise it through their representatives and the democratic organs established by or under the Constitution. How do you relate this issue of the statement by a foreign envoy to the provision of Article 9 of our Constitution?
But when one talks about sovereignty, one is talking about who is ultimately responsible for decision making and for the affairs in a country. That's what sovereignty largely speaks to. We speak about sovereignty of the people. Of course, the people cannot routinely on a daily basis exercise sovereignty. And so sovereignty is exercised through certain organs. You have the parliament being one organ that exercises sovereignty, the executive, and the judicial system. So the combination of those three act routinely on behalf of the people in the exercise of sovereignty. I honestly do not see the statement of the British High Commissioner as an act of sovereignty. She's made a statement, but she's not making the ultimate determination on this matter. So I do not see it necessarily as interfering with sovereignty. But I do see it as interfering in the internal affairs in the extent to which what she is saying may be used to give some legitimacy to the acts of certain people, even those who are exercising. It is a breach of what is required of foreign countries in relation to the internal affairs of a particular country, because it certainly seeks in a very contextually, a very partisan way to influence certain actions which are at the very kernel of our democracy, our elections, and may be seen as a level of interference in internal affairs. I have said that I give her the benefit to get herself out of it, but I think diplomats would be better off not at all getting into it.
There's been a recent bit of information that has emerged which suggests that Guyana's population, and this is going back to your response to an earlier question, I believe the first question with respect to what's happening at GECOM. This information suggests that some 36.4% of Guyana's population reside overseas. It also relates this number, 36.4%, as the largest number of nationals of any country residing outside.
The largest percentage.
The largest percentage. Yes, correct. Residing outside of that country. Now, you spoke to the question of the Chief Justice ruling on removing names from the list in that area. I want to ask you to cast your mind back to 1990, when the elections, regional and national elections, that is, had been put back by 2 years to 1992 to accommodate some changes. One of those changes significantly was the ending of overseas votes, overseas voting. The People's Progressive Party is holding to a position, as you outlined, with respect to residency, not in local government elections context, but in a national elections context. Given all that has been said, and particularly against the backdrop of this 36.4% of our population being resident abroad, would it be fair to say that the People's Progressive Party has moved away from Dr. Jagan's position regarding ending of overseas voting and seeking now, under new leadership, to reinvent overseas voting through another means?
I I wouldn't say that.
Because
I wouldn't say that.
sorry to interrupt you, but if there are persons living abroad and their names are on the list, you don't know if they're dead, but you know that they're not here at the day, on the day of voting, but you know that at the end of the form of backdoor fraudulent.
Well, it's rigging.
voting.
It's not overseas voting. It's rigging. So I wouldn't give it the decency of overseas voting. And that's the point I wanted to make. I don't see them as arguing for overseas voting and, and around that issue. It's clearly, it's evident. It's evident at this time. It's clearly a manipulation of the voters list for the purpose of impersonation and ultimately rigging. But having said that, I want to say two other things. There is a former senior member of the PPP, of the legal fraternity, who has in fact essayed the view that we should return to overseas voting. So separate and apart from answering your question, there are people who have, in their argument about not taking names off of the list, gone to the further stage of saying, yes, there should be overseas voting. So there's that argument also percolating. And as we get to constitutional reform, we may see more views in that regard. But let me emphasize a point I made earlier. The more you talk about how many Guyanese are overseas, it's the more dead Guyanese are overseas. Let me say that again. The more you tell me that our population is so much, and the more you say that of that population, so many are overseas, it's the more you're saying to me that there's so many people who died overseas who are on that list. And the extent to which we have evidence of people who are overseas being voted for is the extent to which we have a problem that has to be corrected. And that problem has to do with a list that allows for persons who are not present to be listed and, as has occurred, to be voted for. That problem has to be resolved. It's a fundamental problem facing GECOM, facing the nation, where our constitution specifies that GECOM is responsible for free, fair, and compliant elections. Our elections were not compliant insofar as there is irrefutable evidence that persons who were not present were voted for. And therefore, we have a problem which we've got to fix, notwithstanding all the arguments that people may raise. They may even raise the argument that, well, the incompliancy is not sufficient to change the results. All right, that's a gone election. But we know what the problem is. We have to confront and solve the problem.
Mr. Alexander, we have about 2 or 3 minutes remaining. I want you to use those 2 or 3 minutes to speak directly to our viewers with respect to the timeline for scheduled local government election and the violations that would make continuing on the path to local government elections in our given circumstances unlawful.
In speaking to the viewers, I would say that the viewers ought to understand that they have to be conscious and aware, because at the end of the day, elections determine their fate. With specific reference to the local government elections, We still have the problem of a list that can facilitate, as has happened in the past, voting that is fraudulent. And people can say how much they care to see that we have the mechanisms to ensure that no one who is not entitled doesn't vote. They can say that as much as they wish to say it. They are hollow words because we have evidence that it has occurred. It is therefore necessary for that matter to be addressed in relation to any voters list. And more specifically, in relation to local government elections, it is essential that the general issue be resolved, that is the quality of our list, and then particularly important that the list is prepared in a manner that does not allow for persons who are outside of the constituency or outside of the local area to be entitled to vote, hence areas which they have no right to. And secondly, the timeline in relation to the attempt to correct the problem does not facilitate the acquisition of the right list for the purpose of determining who can be nominated. It will not be available in a timely manner, and therefore we will have problems, both in terms of exercising the right in terms of whom you extract for nomination, and in terms of probably having people on that list who are not entitled to vote and or to be nominated in relation to a particular constituency. The vigilance of the voters, of the population is required. Ultimately, it's the action of the voters in the population that will determine these matters.
Thank you very much, Mr. Vincent Alexander, GECOM Commissioner. Viewers, you have been tuned to Nation Watch for the last hour or so. I thank you very much for joining us, and I invite you to join us again next Sunday for another program of Nation Watch, a production of the People's National Congress Reform. Thank you for joining us, and thank you once again, Mr. Alexander, for sharing these last 60 minutes or so with us.
Thank you. The pleasure was mine.